Justice Ginsburg had a satisfying day at the office today when she read the decision in United States versus Virginia, a 6-year legal battle which struck down over 150 years of tradition at the Virginia Military Institute, or VMI. Today, I'll be joined by a few colleagues who will help me break down the events that led up to today's landmark decision. Today's podcast will start off with background on VMI, discuss this case and how it made its way to the Supreme Court, review the historical context on the Equal Protection Clause, discuss the political, administration, and legal environment surrounding this decision, and break down what makes today's decision so legally significant. We'll conclude with a special guest to have a quick discussion on the social impact of this case. First, let's learn a little bit about Virginia Military Institute. It was founded in 1839 in Lexington, Virginia. VMI is known for producing exceptional leaders, its robust endowment program, quality academics, and strong athletics. At the time the complaint was filed by the United States against Virginia, VMI and the Citadel were the only two remaining all-male public universities. By contrast, the College of William and Mary admitted their first female undergraduate student in 1918, and University of Virginia started admitting women in 1970. VMI's mission at the time of the case was to produce educated and honorable men, prepared for the varied work of civil life, imbued with love of learning, confident in the functions and attitudes of leadership, possessing a high sense of public service, advocates of the American democracy and free enterprise system, and ready as citizen soldiers to defend their country in time of national peril. Historically famous associates of VMI include General Stonewall Jackson, who served on faculty, General George S. Patton, who started his education at VMI before transferring to West Point. General George C. Marshall graduated from VMI and went on to become the Army Chief of Staff during World War II and won the Nobel Peace Prize for his work on the Marshall Plan. Mel Brooks enrolled at VMI and later went on to co-create Get Smart and direct Spaceballs and wrote and directed Young Frankenstein. Now that we know a little bit about VMI, we'll turn our focus to the case, United States versus Virginia. VMI benefited from federal and state financial support while denying admission to women. Hundreds of women had attempted to gain admission, and VMI did not respond to their inquiries. VMI had refused to admit women because of the adversative method it used in training young men to become leaders and citizen soldiers. VMI held admitting women would create such a dramatic shift that this adversative method could no longer be used, and it would profoundly change the character of the university. Their policy and practice denied women admission into this prestigious, well-endowed university with a strong academic track record and unique method for instilling leadership characteristics that would be beneficial in both professional and military settings. A complaint was filed with the United States Attorney General by a female student who had been denied admission to VMI. The U.S. subsequently sued VMI and Virginia in 1990 on the basis their all-male policy was a violation of the Equal Protection Clause. Following is a summary of the road to the Supreme Court. In 1990, the U.S. filed suit. In 1991, the United States District Court for the Western District of Virginia ruled in VMI's favor. In 1992, the U.S. Court of Appeals for the Fourth Circuit reversed the district's ruling, ordering VMI to remedy the situation. In 1993, the district court reviewed VMI's proposed remedy, a sister program at nearby all-female Mary Baldwin College, and found it to satisfactorily remedy the constitutional violation. In 1994, the Fourth Circuit affirmed the lower court's decision. In 1995, the case was escalated to the Supreme Court for judicial review to determine whether the proposed remedy placed women denied the VMI advantage in the position they would have occupied in the absence of discrimination. In 1996, the Supreme Court heard oral arguments and decided the case. When the issue reached the Supreme Court, they were left to review and answer two questions. First, was VMI's male-only admission policy a violation of the Equal Protection Clause? Second, if it was a violation, was their proposed remedy, the companion program at Mary Baldwin College, sufficiently comparable to VMI's program to satisfy the Equal Protection Clause? Next, we'll look at this clause, which serves as the basis under which the Supreme Court reviewed the constitutionality of VMI's all-male policy. I've asked Jamison Peeler, an American history student at one of our Texas state colleges, to give us some historic perspective around the 14th Amendment and its Equal Protection Clause, before we look specifically at how the Supreme Court considered the case. Thanks for joining us today, Jameson. We know the 14th Amendment wasn't one of the original Bill of Rights. What was happening when this became part of the U.S. Constitution?
The Civil War had just ended. In 1866, Congress had passed the Civil Rights Act. This defined citizenship and protected the civil rights of all citizens. This legislation was primarily intended to clarify citizenship, which included persons of African American descent, whether they were born or brought here. Simultaneous with its passage, Congress pursued a constitutional amendment to provide legal validation of the act. This became the 14th Amendment, which was ratified in 1868. Legislation is relatively easy to amend, but it's hard to change the Constitution, and repealing an amendment has only happened once in our history with the 18th Amendment.
What does the Equal Protection Clause do?
It defines citizenship. It confirms that not only are they citizens of the United States, but also of the state where they live. It prevents states from establishing laws to curtail the rights or protections of its people. It requires states to apply the due process of law before denying their fundamental rights. And it requires states to afford all people within their domain equal protection of the laws.
That sounds so easy. Why are we still trying to figure out what this means 150 years after it became effective?
Because, well, words are hard. How do you determine what groups may be affected because of the law? The original intent was focused on individuals of African descent, but the amendment doesn't specifically call this out. So, what happens when a state practice or policy might infringe on someone's rights based on a factor other than color, like national origin, gender, age, or sexuality? And what if the government thinks that it has a good reason? Who decides if the reason is good enough?
From the 1960s through the mid-1990s, much of what happened as it relates to gender equality and equal protection in political and public administration contexts dealt with addressing employment discrimination. We saw the passage of the Civil Rights Act of 1964, which addressed gender and race discrimination in the workplace. The EEOC was created out of this act and charged with oversight. In the 1970s, Congress passed the Pregnancy Discrimination Act, protecting pregnancy in a manner similar to other temporary disabilities. FMLA was passed in the 1990s, protecting employees who needed to take up to 12 weeks leave to care for immediate family members. The courts were active during this time as well, and I've highlighted a few notable U.S. Supreme Court decisions that preceded United States v. Virginia. Reed v. Reed in 1971 overturned an Idaho law giving deference to men over women in estate administration. Interestingly, Ruth Bader Ginsburg was the attorney who argued the case before the Supreme Court. This case represented the first time where the Supreme Court held a gender-based classification was unconstitutional under the Equal Protection Clause. Ginsburg co-founded ACLU's Women's Right Project and argued over 300 gender equality cases. In 1973, RBG argued Frontiero v. Richardson before the Supreme Court about the ways in which gender discrimination can harm men. In 1976, in Craig v. Boren, RBG filed the amicus brief on behalf of the ACLU, covering equal beer for all genders. This is the case that established the intermediate scrutiny test. The case Mississippi University for Women v. Hogan in 1982 was a public education case tried as a violation of the Equal Protection Clause, wherein a man was denied full admission to the university's all-female nursing program. In this ruling, the U.S. Supreme Court ruled for Hogan, and the majority opinion applied the intermediate scrutiny test and exceedingly persuasive justification arguments. That brings us up to today's decision. Before we look at the decision, I want to take us back to January and an exchange which occurred between the Supreme Court justices and U.S. Attorney Paul Bender during oral arguments. This exchange sets the stage for a surprising conclusion to this case.
We have two separate questions, I think. One, whether the original finding of the lower courts that there was an equal protection violation here of the Constitution for Virginia to have BMI but no comparable program for women, whether that was a correct determination. And secondly, I think we have to decide whether Virginia's proposed remedy of the development of the Mary Baldwin College program is constitutionally adequate as a remedy. And the discussion thus far doesn't really direct us to either of those questions. And I noticed that in your brief, the Solicitor General urges the court to adopt the highest standard of strict scrutiny to decide this case. Does your case depend on that?
No.
Can it be decided, as the lower courts did, on the basis of intermediate scrutiny, as the court has done in the past?
Yes, absolutely.
Up until today's decision, the U.S. Supreme Court had decided gender-based claims based on the standard of intermediate scrutiny. Under this standard, the exclusion must serve important government interests and be substantially related to achievement of those objectives. The Supreme Court majority opinion held there was an Equal Protection Clause violation. The male-only admission policy was not only outdated in that the military had been accepting women enlistees for years, but it was also based on broad generalizations and stereotypes about women's roles and abilities. The court also found the remedy was not appropriate, given it lacked comparability to the VMI program in the education programs offered, program prestige, and differentiated leadership training methodologies. The big case headline today, though, was the introduction of a new standard for deciding gender-based equal protection claims, skeptical scrutiny. This standard pushes the test for gender-specific cases closer to strict scrutiny and requiring the state to bear the entire burden of this justification when evaluating both the policy or the law and the remedy. Under this standard, the burden of exceedingly persuasive justification is demanding, and it rests entirely on the state. The justification must be genuine, not hypothesized or invented post hoc in response to litigation, and the justification cannot be based on stereotypes or overbroad generalizations. Let's look at what the other justices said. First, Clarence Thomas was recused from the case as his son attended VMI. Chief Justice Rehnquist agreed, along with the majority, that there was a constitutional violation and agreed the VWIL program at Mary Baldwin College was not a satisfactory remedy for the reasons similar to those articulated by the court. However, he disagreed with the way the court defined this particular constitutional violation and the corresponding limits placed on the state of Virginia in providing a remedy. Justice Scalia dissented, and in that dissent, he criticized his fellow justices for acting on their own personal views. He argued the U.S. Supreme Court did not have a role in defining education in the state of Virginia and expressed a viewpoint that their role in the Supreme Court was not to fabricate new constitutional tests, but to uphold the Constitution when it is silent on the matter presented before the Supreme Court. In short, he found the Supreme Court's majority opinion had fabricated a new doctrine and was dismissive to and non-deferential towards Virginia's sovereignty. For our last segment, we're going to talk about social impacts of the decision with my daughter, Tessa. Tessa is a rising high school senior who is looking at college programs now. We've talked some about United States versus Virginia, what was decided and why. She has some interesting things to say. Thank you for joining us today, Tessa.
You're welcome. Hi.
What were your thoughts when you heard what was happening at VMI?
I thought it was messed up because I believe that men and women should have the same opportunity in education and in life.
Does it sound like a school you would want to go to?
Me personally, no, because I'm not interested in a program like that, but I'm sure there are others that are interested in a program and a school like that.
If you're not interested, why does their male-only admission policy matter?
Because other women should be allowed to have access to a program like that.
Do you think there are people, male or female, who might benefit from going to an all-female or all-male school?
Yes, I believe it all depends on their preference. If they want to have the option to go to an all-male or an all-female school, they should be allowed that.
But you don't want to?
No.
So if someone can benefit, why kill it?
I don't believe they should kill it. I believe that they should either offer an all-female school that has the same program and same opportunities in education, or they should not take government funds and just become an all-private school.
Tessa and I talked some about other potential forms of gender inequality. Let's discuss those. So, let's say that a local agency is looking to hire someone to work in the field of sewage, and it's going to require the individual to deal with really nasty situations. Is limiting the position to males only okay?
No, because if a woman wants to do that job, she should be able to.
What if the local agency has good intentions and they're attempting to prevent women from being exposed to harmful fumes because they might become pregnant? Does that change it for you?
No, because both men and women would be sitting in the fumes, and so it would affect the male's body too. But if they are worried about the female getting pregnant, then they can just take certain measures when it happens.
Do you ever feel discriminated against because you're a female?
No, but I am worried about equal pay for both men and women for doing the same jobs for the future.
Do you think court decisions like United States versus Virginia have made things better or worse, and why?
Better because, one, they've raised awareness, and they've also opened more opportunities in the workforce and in education for women.